Hello, everyone, and thank you for joining us for this event. I'm Matina Papadaki, and I'm a lecturer in international law at the University of Glasgow. Today, we have the honor to have with us Judge Tladi of the International Court of Justice and Professor Hélène Ruiz Fabri from Université Paris-Sorbonne, Panthéon-Sorbonne. A bit of context very quickly for this event. This is the kickoff inaugural event for the International Procedural Law Research Hub, IPLR Hub. This is an initiative based at the University of Glasgow and led by me and Professor James Devaney, for which we have received funding from the Scottish Council on Global Affairs. The IPLR Hub aims to bring together people working on international procedural law broadly defined. For example, today, Judge Tladi will talk about procedural law at the United Nations Security Council, while Professor Ruiz Fabri will talk about the role of procedure in international courts and tribunals. This broad theme showcases our motivation to deal with international procedure not only in adjudication, but also in international organizations. This talk will be recorded, so please take note if you want to ask questions. This kind of recorded online events will be part of the IPLR Hub as we aim to, among other things, create a bank of resources for students, scholars, and practitioners. The Hub will also have its own webpage and colleagues affiliated with it, and more events and projects are in store and will be announced shortly. So going back to the logistics, we will start with Judge Tladi, who will speak for about 15 minutes, followed directly by Professor Ruiz Fabri, who will speak for another 15 minutes. We hope to have an open discussion for another half hour. So Judge Tladi, the floor is yours.
Very much for the invitation. It really is an honor to be here with all of you. Incidentally, listening to you speak now and introduce, I remembered something that I should have remembered already when you invited me. Is you might know that the American Journal of International Law will have a special issue on reparations and international law. And for that special issue, I have written an article on reparations and jus cogens, and I rely very much on the work, your work, Matina, and also Hélène's work. I just remembered, I'd completely forgotten. I just remembered now as you were speaking on sort of the permeability. I think is the word that you use. I think yes, I think it's the word that you use, sort of between procedure and substance, and how procedure influences substance. And it's only as you were giving the context that I now realize that obviously this is something that you have been working on. In fact, both of you have been working on for some time. So I'm really very happy that that I have an opportunity to be a part of this. On the other hand, so I have to speak about the law of procedure and Security Council. I have to confess at the very beginning, as I told you just before we let all the other guests in, that I don't see myself as an expert in the law of procedure of the Security Council. Of course, I have written about the Security Council, but almost always about the outputs of the Security Council and in some aspects of its substance. And of course, I've also served on the Security Council for 2 years in 2011 and 2012. But through both of these experiences, I have never myself thought long and hard about the procedures of the Security Council. So all of this to say that I feel a little bit like an imposter, and I hope that you will forgive my somewhat out of or rather superficial remarks. So where do I start? Let me start with the obvious. So one of the things that anybody who ever thinks about the procedures of the Security Council is immediately told. In 2011, when I attended my first meeting as a legal advisor of a mission which has just been now elected onto the Security Council, one of the first things that we had a conversation about was the Council's rules of procedure, which of course everyone will know are provisional. They were provisionally adopted in the very first meeting of the Security Council, pending final adoption, which has never happened, and by all accounts will never happen. It will never happen because for members of the Security Council, the fact that they're provisional and not finally adopted means that they're not binding, and so it gives the Security Council members some level of flexibility. The phrase that is often used is the council can, under these circumstances, be a master of its own rules, right? That's a common phrase that's used by council members. In fact, I shouldn't say council members, I should say that's often used by permanent members, explaining why it's a good idea not to adopt these rules of procedure, or not to finally adopt these rules of procedure. Of course, the truth of the matter is that the General Assembly is also a master of its own rules, and yet it has a very thick booklet of rules of procedure that are already adopted. Rules of procedure, like any other rules, are always open to interpretation, are always subject to interpretation, and interpretation, of course, takes place in different ways. It takes place also through through practice, and we've seen that at least with the General Assembly, and certainly with the Council and other organs. I'm sure Hélène will speak about the International Court of Justice. It also interprets its rules, and there are times when there's a clear discrepancy or difference between the rules as you see them as adopted and the practice. And needless to say, of course, this is something that is frustrating for many members of the United Nations, who often speak about how the lack of rules, the lack of formally adopted rules, impacts negatively on transparency. And we'll see that with some examples. Impacts negatively on transparency, impacts negatively on accountability, and so on. If you don't have rules against which conduct can be judged. If I'm going to be honest, I would say that sometimes the issue is more apparent than real. It's more serious than real, because by and large, the council, even though these rules are provisionally adopted, by and large, the council sticks to these rules. There are instances in which it doesn't, but most of the time when there's a divergence between the practice of the council and the rules, it's either a small issue or there's an explanation. So one can think, for example, about speakers lists. The rules say one thing, but the practices something else in terms of sort of the speaking order. There are, however, instances when discrepancy between the rules, the rules as provisionally adopted and the practice can lead to some significant consequences and impact on outcome and substance. Maybe not outcome and substance, but at least certain substantive issues. And I'll give one anecdote. You might remember in 2011, I think it was October 2011, Palestine made this famous request for admission as a member. And of course, there are rules in the rules of procedure of the Security Council and the provisionally adopted rules of procedure governing how this is to be addressed, how the council's function in the admission of members is to be addressed. Those rules require that there's a committee, and that committee will consider the membership in light of the requirements of the charter. And on the basis of this, the council will then make a decision or a recommendation. If the recommendation is yes, the council will inform the General Assembly through a resolution that the answer is yes. If the answer is no, then the council will have a report to the General Assembly informing why the answer is no. And of course, the meeting of the council itself will be a public meeting. It is envisaged. The rules don't say that, but it's clearly envisaged that it will be a public meeting. Well, you might know that indeed the situation or the request was considered by the committee, and there was a Security Council meeting, which was a private meeting. So there's no readout, there's no verbatim record of this, and the council never took a decision. So there was never a yes, and there was never a report explaining why. So obviously, failure to comply with the rules of procedure or to apply the rules of procedure had an impact. And the impact is not just the admission or not, it's also an impact on transparency and accountability. That the council should say why this state or this entity, so depending on where you come from, has not been admitted. Which requirement does it not meet? We can all, you can all speculate. I don't have to speculate. I was there, but the General Assembly doesn't know officially, right? And the public doesn't know officially, and I think that's not good for transparency. So let me say this about so also transparency and accountability, which of course are themes that run through any discussions that relate to the Security Council and rules of procedure. The rules of procedure, the provisionally adopted rules of procedure, they don't say, well, they say that rules are in general to be public, and of course, public meetings enhance accountability. What the rules then say is that the council may make a decision to have private meetings, and that already suggests that this should be exceptional. Private meetings don't have the same accountability and transparency as public meetings, but at least there is something, right? There's something because there has to be a record, and if there's a record of that meeting, somebody will find it, or it could be there's at least a possibility that there's something out there that's written. But what's interesting is, in fact, the council often, at least in my time, in my experience, didn't even meet in a private setting. So it wasn't public or private. Most of the work of the council takes place in so-called informal consultations, for which there's no record. And so there's absolutely no possibility whatsoever of any kind of accountability mechanism. And I think that that's an important deficiency in the council's for functioning. This is nothing new. This is if you have ever walked through the corridors of the United Nations and you've ever been in a meeting of the General Assembly in which the Security Council is discussed, transparency and accountability are the theme. There is one issue that the rules of procedure of the council does not address, which is very strange, that it doesn't address this issue. Well, I mean, it does address, but it doesn't address it sufficiently, let me say. It simply says, so it concerns voting. The rules of procedure say voting shall be in accordance with the Charter of the United Nations, right? Which is strange, in particular because the Charter of the United Nations say one thing about the voting procedure, but the practice is something entirely different, and everybody knows this, right? So the Charter says for a resolution on a substantive matter to be adopted, there has to be affirmative votes of 9, and there has to be the concurrence of all 5 permanent members. Those words would tell you, at least me, the ordinary meaning of those words would tell you that it means that all 5 permanent members must vote in favor, and yet we know that abstentions and that we know that abstentions have been interpreted as concurrence, which is an interesting departure. It's probably a good departure because of the negative impact that the veto has had. But the fact that you have a rule that is in the Charter means that there has to be explanations about why there is this departure. And that's one of, I think, the importance and the significance of sort of having rules that are out there. And the rules don't just have to be in rules of procedure, but having rules that are out there that an entity or an organ of the United Nations can be held accountable to. So the fact that there are resolutions, very important resolutions that are adopted even without the concurrence, as we would understand it, of the permanent 5, there's a reason for that. There's an explanation, a legal justification, and that's why is that? Because there's a rule, and that rule sort of ties the entity and compels the entity to sort of explain whenever there's a departure. I can stop there. I can say a couple of things more about the veto if you wanted. I mean, I thought I might say something about the concerns about the veto. And the concerns about the veto, of course, again, they're well known in the context of the debates in the General Assembly about the reform of the Security Council. One of the the phrases that we often hear is so one of the phrases that we often hear is that the veto is anachronistic. It's a very nice word, this anachronistic word. It's a word that's shared across the various groups that are negotiating or that are engaged in the debates on the reform of the Security Council. What I find really interesting, though, is the various processes, developments that have which attempt to reduce the significance of the veto. So in 2022 there was a resolution adopted by the General Assembly, which requires that in the event of a veto, the General Assembly or the President of the General Assembly calls for a debate, essentially to give an opportunity to the permanent member to justify its veto. I have been terribly unimpressed by this. I think I'm one of the few people who's terribly unimpressed by this this initiative, because again, it's just about forums, right? Because states, whenever they veto, always explain their veto. It's just a question of where they explain the veto, but there's always an explanation, and it's not as if it's not possible for an explanation to come out. I guess it's not impossible that sometime in the future, even this modest mechanism can be strengthened. For example, it's not impossible that the General Assembly might say, well, after this debate, in this particular instance, we want to adopt a resolution expressing our abhorrence at the fact that there has been this veto. I guess it's possible, but I still find it to be a hollow mechanism. They're also out there in the literature. I know there's a very interesting book by a friend of mine, Jennifer Tran, on what is it called, on the legal limits on the right to veto. Again, I find it very interesting, but also I find that it's not a it's very difficult to justify some of the arguments on the basis of the text of the charter. It's not. I also find it very difficult to justify these arguments on the basis of the rules that are often invoked, including jus cogens. But also, and I think for me this is the major policy issue, is that it's easy to say don't use your veto in respect of certain kinds of cases and certain kinds of situations, but there may well be very good reason for not supporting a resolution which concerns the quote-unquote atrocity crimes. And here I have in mind an example by Brazil in 2005 in the resolution on al-Bashir, which they didn't vote against, but they abstained. And interestingly, the reason for the abstention was a reason that you and I will accept. Right? It was a positive reason. It was this resolution, in fact, undermines the ICC. And we have seen how, because of that resolution, the ICC has not been able to fulfill its functions whenever the Security Council has referred a situation to it. So I'll stop there, and I'll be happy to have a conversation.
Thank you very much. So if we can go directly to Professor Ruiz Fabri, and then we will open up for questions. Thank you.
Thank you very much. And, first, I have to apologize because my internet failed, and so I dropped out. And I had to find a way to come back, but I hope it will be fine. Second, I would like to thank you for inviting me to speak about a topic is close to my heart, and I'm also very happy and delighted to speak together with Judge Tladi. We already had this opportunity in the past about jus cogens. I remember, and so it's always a great pleasure. So what is said, I'm sorry, I had a small gap in the middle of what you said, but I think it illustrates very well the key role, but at the same time the fragility of procedural rules. And so, and this is maybe another argument in favor of your project. You speak about reconceptualizing international procedural law, and I think it's really a great idea, as I think we need a reference point, a place where we know people are specifically reflecting on that, and whatever you call it, reconceptualization or another name. The need, in my view, is to acknowledge international procedure law as a specific field, a field on its own right. And it's not about professional pride or having this. This is not the point. It's not for the sake of a specific field, but for several, I think, very valid reasons. And first and foremost, I think it can help fill what I think is a gap between scholars and practitioners. Practitioners are very well aware of the importance of procedural rules. Every time you speak with a diplomat or a lawyer or counsel, they are fully aware of the possibilities and the limits of procedural rules, and maybe they play with these limits, and sometimes they also might try to bullshit procedural rules, but at least they are aware of the importance of international procedural law. And I think a lot needs to be done to increase this awareness, and it's key to understand the dynamics driving international courts and tribunals, of course, which has been my focus so far. But more generally, all decision-making processes, and this is what Judge Tladi explained very well just a few minutes ago. When you speak about procedural rules, it's all about how decisions are made in various contexts or settings. And Judge Tladi mentioned the rising concern about legitimacy and accountability. But reflecting on procedural rules is closely linked to these preoccupations, and they exist for all institutions, not only international courts and tribunal. The importance of how decisions are made is increasing, because it's a bit like what we could call a system of communicating vessels. The more disagreement there is on the merits, the more important how the decision is made becomes. And so the more diverse the decision makers are, the more important procedure becomes. And you can see this in all settings. It might be true in courts, but because our attention is called first to litigation and adjudication, because there the disagreement has become a dispute. So there we know this, but in all settings, and in procedure helps people who disagree to talk together and to take various steps to be able to reach, maybe not, but to reach a decision. So I think there are many common problems and many issues relating to procedural rules which are not specific to international courts and tribunal, which also exist in international organizations and more generally in all settings where decisions are made. And there is not enough awareness about the importance of these rules, because they can play as a door for making a decision, because they will channel the decision-making process, but they can also play as hurdles. So, and this is why my contention has been for years and still is that procedure is never purely technical and procedure is never neutral. And we have to work with these assumptions in mind, because if we do not acknowledge from the start that they are neither purely technical nor purely neutral, then we miss some points which are key and of which practitioners, all practitioners, be they judge, counsels, diplomats, are aware. So, and again, even with this understanding, of course, procedural rules might not be respected, but at the same time, they are at the core of a legal system. So you might say, like some authors wrote at some point, that procedural rules are servants, not master. You can say that they are secondary rules. All this is not that important in my view. For sure, procedural rules are servants in the sense that they are there to help reach a decision on the merits, and therefore define, elaborate, or implement substantive law. But at the same time, I mean, they are saying that in this sense they are secondary is fine, or servants is fine, but it shouldn't be considered as meaning that they have less importance. Because in many cases, I mean, you can use procedural rules not to reach the merits, not to implement rules. And a good example is the Southwest Africa case before the ICJ, when in 1966, the ICJ invented new procedural rules in order to neutralize what had been done in the advisory opinion in the 50s and in 1962. So everyone in the practice know how to use procedural rules. You can speak about instrumentalization, but it's use of procedural rules and strategic use of procedural rules, and we can find many examples in the ICJ case law, of course, but in all courts case law. So we have, this is why I think your approach in the hub you're setting up to your option to have a functionalist approach seems to me particularly adequate in this regard, because it's important to reflect on the role of procedure and to understand that you can maybe identify a few features of international procedural law. You can understand that procedural rules are a kind of a code of conduct. They organize a sequence of events which will help reach a decision. In all procedural rules, including before international courts of tribunal, you will have various steps and various processes which will all involve some negotiations, some verifications, some selection, maybe selection of pieces of evidence. It will be negotiations among judges. It will be acquiring some information and verifying, cross-checking information. All these processes you will find in all decision-making processes, including adjudication and litigation. And so at all these steps, and what Judge Tladi explained about the Security Council before is very valid in this regard. You can shape the information you will draw from the negotiation, from the verification, from the selection, and it will orient the decision-making process, even if the outcome is not known, because by definition, when you come before a court, it's because there is an uncertainty. The uncertainty is at the core of the dispute. It's the point on which the parties disagree, and the judge is the third party who has to decide who is right and who is wrong, or partially right, partially wrong, or it might be that everyone is wrong, by the way, to a certain extent, although it's rarely the outcome of a judicial decision. So choices have to be made, but choices are not only made about the substance of the case, choices are also made before in these various processes you will find at the heart of procedure: selection, deliberation, verification. You select the information that you're going to take on board to make the final decision. So in this sense, procedure is key. And where I also join what Judge Tladi said is that when like-minded people discuss, I mean, you pay less attention to procedural rules because it's easier to discuss. But when you're less like-minded, you need more frame, or a more visible frame. And so this is one remark I would like to make. A second remark I would like to make is that I'm presenting procedure as a frame which make things surer to a certain extent, more certain. But procedural rules are like all legal rules. They are to a certain extent indeterminate. And therefore, the interpretation, this issue also mentioned by Judge Tladi, their interpretation is key. And when you look at the case law, you can see that when a case develops I would say that more than half of the first half of the case revolves around procedural issues. You will have bifurcation, preliminary objections, you will have discussions about the procedural calendar, all these discussions which are sometimes put under the link of case management, but all these issues might occupy counsel and judges for more than half of the time needed for a case. And so, of course, preliminary objections before the ICJ draw some attentions. It might have even been that some periods in the history of courts where the courts made more decisions about preliminary objection than about the merits. But it's a way for me to attract your attention on the importance of these various stages, and even tiny what can look as tiny steps can play an important role. Defining a procedural calendar is very important to the parties because this is where you can also orient a case, and trying to streamline case can have an impact. So each and every step can have an impact on what follows. And my third remark quickly is about procedural justice. I try to show there that procedural law has its own logic, although I also reckon very quickly, again, that we can discuss further, that it's not always easy to distinguish procedural law from substantive law, and both are often intermingled. So you can have a whole site of research just on the distinction of substantive law and procedural law. So I'm fully aware of that. But at the same time, I remain convinced that procedural law, through functional lens, can be to a certain extent isolated in order to study its own logic. And if it's needed, it's also for the sake of procedural justice, because especially in adjudication, but it's not the only thing. I mean, decisions, when they are made, they need to be acceptable. So, and for this, they need to be considered legitimate. So I will not necessarily open the whole debate on the legitimacy of decisions, but I'm sure that procedure plays an important role for a decision to be acceptable, including by the party losing a case or by the states being in a minority in the decision making. People, be they individuals or state, need to have the feeling that the process leading to the decision has been fair, and fair by itself, because it helps making the decision acceptable, even if the content is not satisfactory for one of the parties. And this aspect of procedural justice, I mean, it has been studied by John Rawls and a few people, but it has barely been isolated and studied as such. And you have a few research about accountability, legitimacy, independence, but focusing on procedural justice has barely been done so far. And yet, if you agree with all what I've said so far and what Judge Tladi explained, it would deserve, I think, a focus. So maybe I stop there for now in order to leave time for questions. But I mean, in as much as I think it's a field of its own right, I could speak about it for hours, you can guess. Thank you very much for your attention.
Thank you very much, Professor Ruiz Fabri, and thank you very much, Judge Tladi, as well. I mean, we're very grateful to have you sort of help us to kick things off today, and I think these were two great sort of agenda-setting speeches here that really raised a lot of the issues that were in our minds when we were putting the idea for the IPLR Hub together. We're keen to hear from other people. We have many participants with us today. So if you do have any questions, please put them in the chat or simply raise your hand and I will call on you. And maybe while people are thinking of their questions and formulating them, finally, I can kick us off just with a short question on for both speakers on something that Hélène mentioned, but I think that maybe we could go a bit deeper into, and that's the idea of taking a functional approach to procedure. So we have the idea of looking at procedure as something that is not just confined to international courts, but I think we already know that there are some people who will be skeptical about this approach, and there will be some people who will feel like there is something that is particular, that is special about, for example, legal procedure or procedure relating to the adjudicative process, and then would maybe cast doubt on the ability for us to make meaningful comparisons or to speak generally about procedure if we compare, for example, the workings of the ICJ or the Security Council. So maybe if we could start with the original order of the speakers and just ask if you have any brief reflections on this skepticism that some might have about speaking generally about international procedural law.
I mean, I guess there's always skepticism, right? And there's some truth to that. The fact of the matter is that with most things, one has to be cautious about generalizations. But also with most things, there's always the ability to draw from different rules, from different forums, from different circumstances, from different events and developments, certain general issues. I think Hélène was very clear that there is a link between substance, outcomes, and procedures. You can see that in the court, as she has demonstrated. But I think I also showed how, in the context of the Security Council, with one specific issue, the procedure, following or not following the procedure, I think it had an impact on the outcome. I think if the procedure had been followed in that instance, it may well have been very difficult for that one state that wanted to, or that had expressed, I think somebody in the chat wrote something like a pocket veto. It's very possible that if this had been a public process, as it is expected to be, that veto may in fact not have happened, and so it may well have affected the outcome. These are two different institutions that fulfill two very different functions, but it's clear that for both of them, in both of them at least, the application and the way in which the rules are applied has an impact on the outcome. So yeah, I think that there's that it's a skepticism that has to be responded to, but I think that there are responses, and as long as one is nuanced and one is not overly definitive about the project, then it should be possible, I think, to explain or to respond.
Yeah, thank you. I mean, of course, it raises interesting questions about the nature of the Security Council itself. I mean, is it a purely political body? Is it sometimes acting as a quasi-legal body? And does that change its approach to procedural rules or procedural justice, as mentioned by Hélène as well? Hélène, I wonder if you had anything you would want to add to your original your opening.
Yes, a few words. I see this skepticism, and also it is fed by. I've seen a lot of quotations, including from the ICJ, saying that it was not bound to attach to issues of form as much importance as substance, and this kind of remark. But I think we pay too much attention to this type of remark, because issues of form does not summarize procedure, in my view. So this is one thing. The second is interesting because in French, we have two different words. We have droit procédural, procedural law, and we have droit processuel. And procedural law in a way, or I don't know how we would translate it. But droit processuel is a procedural law in litigation. So it's a part of procedural law. But you have procedure everywhere, whether people like it or not, you have procedure everywhere. So you can try to downsize its importance, but you won't change the fact. And if you participate in an international negotiation, every time a state puts its plate in the vertical, raising a point of order, the process is interrupted. Procedural issues take over. So in a way or another, I mean, you have to take this into account. The second remark, very briefly, is that I fully agree that procedure can shape substance as a bearing on the outcome. And so this is why I contend that procedure is not neutral, because you can orient the outcome by the way you use procedural rules. So there we are in full agreement. And, but it doesn't mean that both can be just merged and considered as a big whole, because it doesn't help. I mean, I think that distinguishing procedural law, even with the limits of this distinction in terms of boundaries, help identifying the specific role of procedure and be aware of precisely the way the ways of using procedure can have an impact on the outcome. So, and my third remark, very briefly again, is that we can distinguish judicial procedure, or what happens before adjudicatory bodies, from the rest to a certain extent, with one fact, is that judges are bound to decide. Whatever they decide, they are bound to decide. I mean, a political organ like the Security Council can decide not to decide, whereas a court or a tribunal has to decide in a way or another. It cannot leave a case open without making a decision, including to reject the case and to close it. And so I think the various institutional positions also have to be taken into account. But I know no institution, political or legal, which can function without procedural rules.
Yeah, of course. Yeah. And these sorts of procedural challenges are in the mind, I think, clearly of the ICJ at the moment, given this, phenomenon of mass participation, whether that be in, what some might say case management, how much time are states going to get when they either intervene or they want to participate in advisory proceedings. And we've seen even the court being willing to engage in some sort of, let's say, minor, maybe not so minor procedural reforms in response to recent developments. So I think these are issues that are, not only of theoretical and conceptual interest, but also very much practical and contemporary interest at the moment as well. So I'm keen to open up to hear from other people. Oh, sorry.
Yeah, I had a question actually about what Hélène just said towards the end there. The difference between a court and a political organ, like say the Security Council. The court is bound to decide, and a political organ isn't. And it actually made me think of something that you both had said about the fluidity of distinctions. I mean, I wonder if even here there isn't a fluidity in distinctions, because in a sense you can say, well, a court can decide not to decide by, for example, saying we're striking the court off the roll because I'm just thinking a couple of weeks ago, so the Sudan versus UAE case, it decided nothing really, right? It was, and on the other hand, I guess also you could say when an organ, like the Security Council, decides not to decide, it has actually made a decision. There's a decision there not to decide, and this again made me think about how everything is fluid, and so distinctions. One always has to be careful about distinctions, because there's always a point at which most things, not everything, but most things sort of come together. And I just wondered what you thought about that. If it's a...
No, I agree with you on that. What I meant by duty to decide is that the judge, whether taking the case or rejecting it, makes a decision as well. So when I said that a political organ could, even in this case, the judge will not decide on the merits, but it will decide not to take the case. So you have a decision and it satisfies its duty to decide. What if you could say when a political organ remains silent, it's a way of deciding, and there I agree with you, and the fluidity of the decision-making process. But it could always it could also decide just to defer the decision and defer the decision and defer the decision, so that no decision is made, or send it back to commissions, and you say this type of thing. Whereas when the judge decide to strike a case from its docket, then the decision is somehow final.
Matina, would you like to add anything to this?
Okay, so I think I have too many things to add, so I will not, though. But I first comment on the discussion so far, which is this permeability of boundaries between substance and procedure is the important thing as well, because there is you can see, if by looking how the procedure is set up, you can see the values that it enhances. And in that way, who can participate, who gets to talk when, across different fora, is something that comes out not only by studying the procedural isolated from the substance, or the substance isolated from the procedure. So there's a critical research that needs to be done there. And my question kind of links to that and follows from a comment by Judge Tladi about the criticism of anachronism in the Security Council. So the veto and anachronism. And I was thinking while I was listening to that about procedure evolving, and whether a procedure can evolve faster than substance to allow for change. And by that I mean, Professor Ruiz Fabri mentioned the Southwest Africa cases, and now we have erga omnes partes cases. And so we see in the standing and evolution that's happening procedurally, the substance seems to have remained the same, but there seems to be more permeability. So I was wondering whether you have any comments on this kind of, law is always encapsulating certain moments, and it's not forward-looking most of the times in terms of substance. Sometimes it can lag behind. Can procedure catch up in that, or is procedure bound by the same kind of restrictions, if that makes any sense? Yeah.
Well, that's a fascinating question. I thought you were asking me something. So I thought you were asking me whether or not procedure can actually lead substance, where it is procedure. I mean, the example that you've given of initially a retardation in 1966, but then fast forward to 1970, 2019, maybe 2026, 2027, maybe, where you see this embracing of a procedural rule for standing, which is not followed by a related substantive issue. So with all of these, I mean, in terms of the evolution of the procedural rule that you're talking about, it has so far been in the context of genocide, right? And yet another, actually, this is also a procedural issue. A procedure substance issue arises in respect of the same offense or the same crime rule, and consent to jurisdiction, and there isn't a development, and I think that has a lot to do with the. I mean, it's a really fascinating question, so I haven't thought about it, but I think it has a lot to do with the slow pace of development of the substantive rule in respect of genocide, because I think the rule on standing, if one is thinking about this continuum that you have written about, I think the rule on standing is much closer to procedure than is the rule of consent to jurisdiction. That has a lot more element, I think, of substance, and so you may well be right about that. But I haven't thought about it, but I think it's a fascinating question.
Yeah, no, I also agree that there is a kind of temporality which is at play in this, and I think it's also maybe a danger regarding procedural law, that it takes too much room and doesn't evolve at the same pace as substantive law. And this is, I mean, you have two phases to that. I think procedural rules are adaptable. But also, for example, when you look at case law at the beginning of the century, mixed arbitral tribunals or old arbitration, you will see arbitrators or stating it is common sense that, and justifying a certain number of procedural issues, but it's because it's common sense. Nowadays, it's not possible anymore for a judge to say it is common sense. They would have to back what they say based on a rule and a rule which is clearly identified. So this is where procedural law can become very constraining in a way, because you have to justify things not only with regard to substance, but also with regard to procedure. But at the same time, procedural rules are adaptable. So there is a fine balance to be found, and between not paying attention to procedure and paying too much attention to it. But at the same time, paying too much attention to procedural rule is a sign of a deep disagreement on the merits, because you fight on procedure first. So this is one thing. And the second thing, which is not contradictory, but which is rather different, my experience in studying procedural law, not only at the international level, is that when you speak about procedure, this is where you find the most striking cultural features in legal systems. I mean, the deep features of a legal culture are first and foremost procedural. If you want to compare common law systems and civil law systems, which are the ones I know best, and so it's not due to an imperialist stance that I mentioned them, it's just what I know, is that the main differences are procedural. You will find the same substantive answers, but you will find very different procedural answers. It means that procedural law is the law which is the most difficult to harmonize. And this is why sometimes the rules of international courts can look a bit messy, because you try to reconcile very different points of view and approaches to procedure. And it's a field where people may have more difficulties to discuss and to identify their disagreements than in substantive law. And so I think it has also to be kept in mind.
Yeah, I think, as Hélène said, we could talk amongst ourselves about this until the cows come home. But maybe before the hour runs out, we should try to gather some questions. And maybe when people are asking their questions, they could introduce themselves and say where they're speaking to us from. Millicent, you have your hand up. Would you like to ask a question?
Yes, I would like to ask a question. Thank you so much to Judge Ruiz and Professor Tladi for your insights. My name is Millicent Madiwa. I'm dialing in from Aberdeen, a current LLM student in criminal justice and human rights at the University of Aberdeen. Just out of curiosity, as a young developing mind in international criminal law, I'm just wondering, perhaps Judge Ruiz, you could also answer it from the ICJ perspective, and then Professor Tladi, you could also answer it from the Security Council perspective, or from emanating from your experience, of course. I'm just thinking, given the current procedure within the Security Council, is it still capable of taking action on threats against peace, which come in form of human rights violations? I understand that there was a point in 1966 in the situation of the then Rhodesia, which is now Zimbabwe. The Security Council did take a standing in that matter. But to further on continue with my question, given the current situation with the veto power and, relating to the political interests of the permanent members, do you think the Security Council is actually still capable enough to making decisive strides in that aspect? Thank you.
Who would like to take this one?
I mean, whether or not the council is able to act is always dependent on dynamics. Dependent on dynamics, geopolitical dynamics, and it's also dependent on the issue. My experience is that when the five are aligned, and it's possible for them to be aligned, or when their interests aren't too far apart, then there's always a possibility for taking a decision. In the current geopolitical context, I think it's going to be a lot more difficult because of the events of the last couple of years, so that it's not even about the issue, it's more about their relationship. I mean, this is now speaking as an amateur political commentator, because this is not my day job, but that's my sense. My sense is that whether or not a decision is able to be made is dependent on many things: geopolitical considerations, the issue, the current relationship between them, but maybe also a lot of pressure externally. I think that may also play a role. So yes, it's possible, and there have been instances, in the last decade where we have been surprised. In the last 15 years, where we've been surprised. I mean, who would have thought in 2011, in the first 3 or 4 months, the council took 2 decisions on the use of force in the first 3 or 4 months of the year. And in that same phase, took a decision on, referring a situation to the ICC. So in a space of 4 or 5 months, 3 very significant decisions, all related to human rights. I think that an indication that these things can happen, but it'll always be like this, right? It'll always change and so on.
Right. Thank you. I mean, a difficult question. I think we can agree. I realize we're rapidly running out of time. I wonder if there are any final questions on issues of procedure and substance from those in attendance that anyone might like to ask. Yes, Marina, please go ahead.
Hello, my name is Marina Girshovich, and I'm joining this event from Kazakhstan. It is a great pleasure to be here. It was an honor to listen to the keynote speakers speak, and it's a great pleasure to be here. My question concerns unilateral actions of states. I wonder to what extent they may be addressed within the scope of the international procedural law. And I'm talking about the unilateral actions by states outside the international institutions. So we have heard about the international courts, we have heard about the international institutions and the international organizations, but what about the unilateral actions outside? What happens before the states actually go to the international institutions? For example, unilateral sanctions or other interactions that states engage in outside the international institutions. This is my question to both speakers. Thank you.
Thank you. Interesting question. Yeah. Again, who would, Hélène, would you like to start this time?
Oh, I can start. You have several aspects which can be taken into account. I mean, for sure, international law barely regulates unilateral actions by states, although you have a reflection on the legal value of unilateral acts. But states are aware of that. They are aware of the rules constraining their power to act. They can decide to just not to take these rules into account, but it depends on the effect they are looking for. And for example, if a state wants a statement to be taken into account at the international level, in international law, it will take care of having the statement made by someone supposed to be representing the state, as acknowledged, for example, in the Vienna Convention on the Law of Treaties, the head of state, the prime minister, the minister of foreign affairs. So, and for example, in the nuclear test case, and in 1974, the ICJ took into account a declaration by the president of the French president of the Republic, but in a press conference. So the setting didn't count. What counted is that the statement was made by someone able to commit the state. So you have some rules you can find dispersed rather dispersed rules, but which play a role in or have a bearing on unilateral actions of state. But this is not codified anywhere. You would have to pick up rules all around. This is only one example which comes to my mind.
Can I just make one point? I would not have had an intelligent answer to that question, so I'm glad that Hélène responded. What I will say, though, is that question and the response just given shows, I think, the point about how fluid these distinctions are. Because when the question was asked, my immediate thought was, but this is a substantive question. It's a question that's based on substantive law and not procedural law. So I think it just goes to show. So I think it's an excellent way to show the interconnections.
Very much agreed. I'm afraid that we're out of time and we need to let our speakers get on with their days. Barak, apologies to you, but there will be many more IPLR Hub events in the future, and I'm sure that we will come back to many of these issues that are raised today. I would just thank our speakers very much for kicking us off and maybe leave the floor to Matina to say a final word.
And for me, just to thank everyone for coming today and to our speakers for excellent talks and discussion points that open up our agenda and kind of verify our intuition that there's still a lot to be explored and gained from this kind of research agenda and discussions. Thank you all very much.